afternoon. Now we are going to start this afternoon session 3, that is reviewing the procedure and practice of the judicial appointment in India. And we have 1 hour. After that, we are going to see the Supreme Court of India. So procedure will review, and you all will have an opportunity to find out what actually there in the Supreme Court of India. So 3 o'clock you proceed from here to the Supreme Court of India, and 5 o'clock also we have invited Honorable Justice Madan B. Lokar to the Indian Law Institute. So I think that questions you all have from the morning to evening, you will get a chance also to interact with the senior most judge of the Supreme Court of India today. He has also consented to come and interact with you for 1 hour. So I think some of the questions you can keep in your mind, you can discuss here in the in venue and also in the Indian Law Institute, interacting with the Honorable Justice Supreme Court of India. We have 2 important, very eminent speakers, and I think you all will be enriched by hearing Professor Mahendra Pal Singh, visiting professor, National Law University, Delhi, India, and former professor of Law, University of Delhi, and former Vice Chancellor of West Bengal National University of Judicial Sciences. I have personally great association with the Professor M.P. Singh and Professor Upendra Bakshi sir. I feel blessed and fortunate that I have opportunity to interact with them frequently and learn a lot of things about the Constitution and other aspects. Then we have other speaker, Khagesh Gautam. He is Associate Professor in Jindal Global Law School, India. He is going to speak on the use of basic structure doctrine in the 4th judge's case, some critical comments. And we are expecting the 3rd speaker, that this Senior Advocate, Supreme Court of India, Prashant Bhushan. He may join us in between 2:30. In case he fails to come, then we'll continue with the 2 speakers. So what I request to the speakers that we have 20 minutes, sir, and then remaining 20 minutes we'll keep for the question answer. With this, I request Professor M.P. Singh to share his thought about the subject. Thank you.
Good afternoon, everyone. Actually, until Professor Shetrit, on whose writings I have relied quite much in writing that paper which Professor Rajkumar mentioned this morning on the independence of the judiciary. Professor Bakshi's remarks with respect to the drawbacks and also the stronger points of what the court has decided, that is the both kinds of issues he has mentioned. In the background of that, I think there is not much new which I can tell. I start with a little bit background of why all this new procedure is started and how it was evolved. As a matter of fact, until 1993, almost mid-1993, there was no apparent controversy with respect to the appointment of the judges. There may have been some controversies, but which remained unknown to the public. It is only in 1993 that the President of India appointed Chief Justice, not the senior most judge as used to be the case earlier for all the 23 years in the Supreme Court. Suddenly, number 4 judge was proposed to be the Chief Justice of India, and he was appointed as Chief Justice of India. It is at that time that the problem started arising. The 3 judges who were senior to this 4th one, they all resigned in protest. And this was repeated again in 1976 when Justice Khanna, who had given a decision in a way against the government in the Supreme Court. He was also superseded by a judge who was junior to him, and he was made the Chief Justice of India and not Justice Khanna. Now it is in that situation actually the first case relating to the judges was brought in 1980. And there again, because by that time the same Prime Minister had come back into power, and it is in that atmosphere again, the court, perhaps, I don't know whether that was the reason, under the influence or irrespective of the influence, the majority of the judges came to the conclusion that the new procedure which has been proposed is not legitimate, and whatever the government has done or the president has done is within the power of the government. It is this situation which was established until 1980. But by 1991, actually the position had started changing. While earlier, as it was said, that normally judges were appointed on the advice of the Chief Justice of India, in these 3 years, 3 persons were appointed against the wishes of the Chief Justice of India to the Supreme Court. And it is at that time that the new petitions started coming to the Supreme Court, and they were collected for the purpose of being given a hearing by a larger bench of the Supreme Court. That is how the first case was decided in 1993, in which the court laid down this new procedure. The case remained somehow uncertain and unclear on some of the points, and therefore the next Chief Justice, when his turn came, he did not follow exactly that procedure. Rather, he followed a different procedure with respect to some of the matters. It is at that point that the President of India was asked to send a reference to the Supreme Court for its opinion, and the Supreme Court, in its opinion, unanimously, 9 judges of the Supreme Court, senior-most 9 judges of the Supreme Court, they unanimously decided that the procedure which has been laid down in that 1993 case, with some improvements and modifications, will be the right procedure for the appointment of the judges. And the reasons which were given in the 1993 case and again repeated in 1999 case, they were actually based on the principle of basic structure of the Constitution, which had been laid down in 1993 by the Supreme Court, after which the Prime Minister or the President actually superseded the 3 judges. So it is among the basic features or the structure of the Constitution, one of them was the independence of the judiciary. And as a matter of fact, if we go to history of the Constitution making, we find that so far as the makers of the Constitution, that is the President of the Constituent Assembly, as well as the Chairman of the Drafting Committee, they made very clear statements so far as the judiciary was concerned, that we want a judiciary which is competent to carry out the goals of the Supreme Court. And for the same purpose, the chairman of the drafting committee of the Constitution, he also said that we also not only independent judiciary, but we also want competent judiciary. That is, both kinds of conditions should be fulfilled with respect to the judges. And the judges have to be appointed that way. And one of the goals behind this was that because the Constitution actually wants to achieve certain goals, which Grenville Austin said revolutionary goals, but later on, perhaps a better language have been developed by Professor Kale of South Africa, that a transformative role which the judges have to exercise under the transformative constitution. And it is on that basis, therefore, it appeared to me that in the light of the experience which we have since 1993, it was, I think, right that the court developed a new procedure which was not discussed, means all kinds of existing models of appointment of the judges were discussed in the Constituent Assembly, including the model relating to the Judicial Appointments Commission. And they were all rejected by the constitution makers. And finally, something which could be similar to the position in England, that is on the advice of the Chief Justice of India, the President will appoint the judges. Maybe the Chief Justice was replaced by Lord Chancellor. Lord Chancellor, though of course, as Professor Shetrit said, he had 3 roles, but basically main role of his was as head of the judiciary or head of the legal department. And therefore, there was some justification for that. And this model, therefore, impliedly the constitution makers adopted. Now, as there was a disturbance, as there was, the position was changed by the government, the court had to ensure as to how we can protect the independence of the judiciary. And independence of the judiciary actually was necessary. Again, the constitution makers were very clear that the goals that we want to achieve through the constitution, including the goal of maintaining democracy in the country, they can be achieved only through an independent judiciary. Means that the judiciary will have to, I am not saying only, but definitely the judiciary will have to play a crucial role. And for playing that crucial role, the judiciary must be independent as well as competent. Now, I don't know whether or we can't say very clearly, whether all the judges which the government appointed during 1993 up to 1973 up to the 1987 or 1993, whether all of them were superior to the kind of judges which were appointed earlier. But even if they were superior, there was a possibility that the government could misuse its powers, and to control that, the possibility of that misuse, and to ensure that the goals of the constitution makers are achieved, the judiciary actually created this new procedure. I had no doubt that the case, the judicial commission case, which finally was decided, NJAC case, which was decided, Neeraj remembers that after he gave a talk on the radio, and I heard it, I told him that, of course, you defended the position very strongly, but I have doubts whether your position will be accepted. Therefore, naturally, though, of course, one of the judges gave a dissenting opinion, but the majority of the Supreme Court came to the conclusion that so far as these, the amendments which have been made to the Constitution, that everywhere, wherever there was a reference to the Chief Justice of India, it was replaced by reference to the National Judicial Commission. This way, the position of the Chief Justice of India was reduced in the matter of appointment and transfer of the High Court judges. Now, I think that so far as this issue is concerned, the only question now to be considered is that whether in those circumstances that happened in India, what the court has done goes against the wishes of the constitution makers, or what is impliedly and expressly represented in the Constitution. Whether it is also supportive of those goals, that is the achievement of social change or social reforms, and also democracy. Apparently, if one would analyze, I feel that so far as democracy is concerned, this has been really a clearly supportive judgment, that is the 1993 judgment, the 1998 judgment, and again, so far as this NJC decision is concerned, these all three decisions are supportive of democracy. Otherwise, I am not sure what kind of judges would have been appointed during these last 3-4 years, and whether the democracy, the way it has been so far in this country, would have grown in the same or strengthened in the same way, or it would have become weak. I have my own doubts. I feel that perhaps there was a danger to the constitutional government as well as democracy in the kind of situations in which these amendments were made, and subsequently the way the government has gone or the state has gone. Now, in this background, I feel that so far as the present tradition which has been developed, which at the end of his lecture, Professor Shetrit justified by saying that a legitimate practice for the preservation of democracy or a democratic procedure can be one way of selecting the judges, and it may be justified. So this is all what I had to say. I don't think that there is any new point which I have to mention. So leaving more time for the questions, I end up here. Thank you very much.
Thank you, sir. Now I'd like to request Khages.
Good afternoon to all of you. My difficulty with making this presentation is that I have a very special connection with the fourth judge's case. Raj knows about this. Raj and I, as he mentioned in the morning, were making a small presentation. Raj was making the presentation, but we had written the paper together. And barely 5 minutes into the end of that presentation, the Supreme Court declared the law, the 99th Amendment, and the NJAC Act was declared invalid. And almost immediately, the arguments that were being made, well, if I may use a phrase that Raj used, they had to eat humble pie anyway. The date is also important for me because the next day I was to get engaged, and a week after I was to get married, so I had to rush from Bhopal back. I will never forget the background in which this happened. Now, barely 3 years into my marriage. Now I'm defending it and never thought I'll get a chance to speak about this again. I'll make 7 broad claims, and if questioned, I can expand on that. But after much, and of course, a quick side note, after the case came out, I wrote a very long comment justifying why there is a very deep, long-standing pre-independence as well as post-independence historical reason why the judges in India, or rather why the executive branch can't be allowed to have a determinative role in the appointment of judges in the higher judiciary in India. They don't have a determinative role in the appointment of what we call lower judiciary, what you might call as trial courts, but in the appointment of higher judges, that is judges of the High Court and the Supreme Court, the executive branch was never intended to be, never indeed had, and under Indian circumstances, I agree with Raj, it can, for the foreseeable future, not be allowed to have a determinative role. That is the interpretation placed upon the Article 124 of the Constitution in the second judge's case. Many people have criticized the second judge's case. Third judge's case is relatively insignificant because it just increases the size of collegium to 3 to 5 and sometimes even 6 judges. Sixth judge being, if the next chief is not in the current line of 4 judges, then it has to be 6 judges. Fourth judge's case has been criticized on the ground that the word consultation in Article 124 has been read as concurring. I would invite anybody to point out any passage in the opinion of Justice Verma or of the concurring opinion where it has been held. What has been held in second judge's case, and this is important for my first claim, is this. Article 124 only says that the President shall consult such judges of the Supreme Court and of the High Court as the President may deem necessary for appointment of judges to the Supreme Court. There is a parallel provision for the High Courts. Whether or not the President of India should be bound by the advice of the Cabinet, the word the Constitution uses is the Council of Ministers, is no longer an open question. The 7-judge bench in Shamsher Singh's case, very popular case in India, has held that the President, for all intents and purposes, is always bound by the advice of the Council of Ministers. That's Article 74, Clause 1. Now, my first submission to you is that the judgment in Shamsher Singh's case is incorrect. I have written a very long article in which I can't go right now explaining as to my reasons as to why Shamsher Singh does violence to the language of Article 74. Now, if you look at the intended objective of Article 74, the Presidential Aid and Advice Clause, the President was expected to exercise his discretion personally in certain areas. 124 is one of those areas. If you look at the debates, consistently in the debates, it was pointed out by everybody, whether or not their amendments got accepted or rejected, that it is the concurrence of the Chief Justice that we want, not just mere consultation. And the idea of concurrence was rejected deliberately on the understanding that consultation indeed means concurrence, because that is how the appointments were being made to the Federal Court of India. Subsequently, that's how the appointments were made to the Supreme Court and various high courts, and there is enough historical evidence to support that, which I've recorded elsewhere, so I won't go into it. What's the problem with, so point number 1, second judge's case never held, it has to be concurrence. There was a legitimate point of constitutional interpretation in the second judge's case, which was when the President is being given conflicting advice in the matters of appointment of judges to higher judiciary, what is the President to do? Is he to be bound by the advice tendered by the Council of Ministers under Article 71, which is the law laid down in Shamsher Singh's case, or is he to defer to the advice given by the Chief Justice? This is a genuine question of constitutional interpretation, and on that ground, most respectfully, I reject as incorrect any criticism of the second judge's case that says that the Constitution was amended, so to speak. Those who say it was amended don't have an idea of the drafting history, which is very peculiar. Having decided that question, that in the case of a conflict, the advice of the Chief Justice and the collegium, which was initially 3 judges, now 5, has to be followed. In that light, the question is, was the National Judicial Appointments Amendment, the 99th Amendment, and whether the act that followed the amendment, were they somehow violative of the basic structure? Now, again, before we start into a long-winded criticism of the judgment, we have to understand a very technical point. The Supreme Court of India in the fourth judge's case never examined the validity of the NGAC Act. There was no reason to, because the amendment was already declared invalid, so the act had to be declared consequentially as invalid. So to that extent, no logic is available, neither there is any need. The moment you say the amendment goes, the act has to go automatically. Now, most of you have been very generously given a copy of the Constitution by our partners. I would point your attention to Article 124A, Clause 2. Just take 1 minute and read that. Article 124A, Clause 2, inserted by Section 3 of the 99th Amendment, specifically says that if the constitution of the NJAC is not complete, any proceeding of the NJAC can't be questioned on the ground that the constitution of the NJAC, the 6 members were not sitting. In other words, there is no requirement to make sure there is a quorum available to take any decisions. I'll give you 1 minute to examine Article 124, capital A, subclause 2. It specifically says that. Now, right, I don't think anybody will dispute this proposition of law. It's taken from the text. If you look at the judgments of the Supreme Court, judicial review has been held to be a part of the basic structure in n number of cases. For example, Indira Gandhi versus Raj Narayan, the first post-basic structure case, Minerva Mills case, I.R. Coelho's case, then there are a whole number of cases. Nobody in this country and outside can deny the fact that judicial review is a part of the basic structure of the Constitution. Article 124A, Clause 2, clearly violates the basic structure of judicial review, and there is another 5-judge bench where a kind of a similar article was struck down as invalid. Now, we are left with Article 124, capital A, Clause 1. That's where the entire dispute is. 124B and 124C are consequential provisions. Once 124A goes, they have no place. The entire dispute, the entire forensic effort that we have has to be focused on 124A, Clause 1. Was it constitutionally invalid so that it violates the basic structure? Here is my view on the subject. I don't think NJAC, the idea of a National Judicial Appointments Commission, is violative of the basic structure. To that extent, I defer to the views. In fact, I agree with the views of Upen, which he has covered already, so I won't go into it. Our Constitution doesn't say you can't have a National Judicial Appointments Commission or a body of that kind. That's not violative of the Constitution. What was violative was the manner in which NJAC was constituted in this particular case. Now, if you look at 124, the clause 2 that I've just pointed out, the entire industry and hard work of the Supreme Court and the bar at the Supreme Court in second and third judges was to make sure that the judges are appointed in a manner which doesn't take away the independence of the Supreme Court. Now, I submit to you that in India, you can't equate the Indian Parliament with British Parliament. British Parliament is sovereign. It derives its authority on a historical custom, that the fact that people have directly elected MPs into it, and so on and so forth. Indian Parliament is equivalent to British Parliament only in name. It's a constitutionally created institution. It could have been called the National Legislature, or for that matter, the cricket stadium of Mohali, I don't care. It's an institution created by the Constitution. When anybody is elected or selected or nominated or appointed to any constitutional institution in a country like India, their legitimacy is drawn from the Constitution directly. It can never be drawn from the people. The legitimacy of the Supreme Court is because the Constitution established it. The legitimacy of the Supreme Court cannot possibly be that the people have selected a particular person to be a judge in that institution. If we start going down that line, then the entire basic structure case was wrong, and the entire Constitution is amendable by an executive order, which I'm sure is a proposition that nobody here will accept. On that ground, I submit to you that it might be the case to seek legitimacy of judicial nominees and judicial appointees in foreign systems based on how widespread their democratic acceptance is, but in India you can't do that. In India, what process is to be followed to appoint judges in the Supreme Court is squarely and simply a matter of constitutional interpretation and a matter of constitutional design. In that constitutional design, the most, and I most respectfully submit, in my opinion, the only consideration that has a consistent historical evidence to support itself is the consideration that the involvement of the executive branch was always supposed to be non-determinative, if you will, an arm's length approach. They can be a part of the system, they can have a seat at the table, but they cannot have the last word. They were not allowed to have the last word for a long time, and that's exactly what was intended when the word consultation was used. In that light, have we arrived at a situation in this country where we can do away with that historically important requirement of constitutional design? I submit to you that we can't. There is ample evidence to support that we can't. There is ample opinion of other scholars and people who have critiqued the decision who also supports this idea. On that ground, Article 124A1 was, I don't think it was inconsistent with the basic structure. It was inconsistent with a historically relevant consideration in constitutional design. Could it be declared as invalid of the basic structure on that ground? Perhaps yes, perhaps not. But at the end, you will realize Article 124A, Clause 1, when everything is said and done, was like a half-baked cake. You can't eat it. You have to throw it out. What else can you do? It's sad, but that's the only option left. Without 124A clause 2B and C and so on and so forth, there's nothing else you can do. Now, did the court go slightly overbroad? Yes, the court indeed did. In fact, in one of the most important criticisms of the judgment, senior advocate, a very learned member of the bar, very eminent member of the bar, Raju Ramchandran, has argued that primacy to the opinion of the collegium is a derived factor. It's derived by the application of the principle of independence of judiciary. Now, he says you can't have a derived factor read back into the idea of basic structure. I agree with that. Our own, my friend, our previous colleague, Rehan Abiratne, has written a very good article in George Washington International Law Review, by and large making the same point. With respect, I agree with part of what they've said. I don't necessarily agree with Raju Ramchandran's point that a derived structure or a derived factor can't be part of basic structure. For example, and relying on one of the only unanimous basic structure decisions, I.R. Kohilo, which is a 9-judge bench, there is no dissent in this case. Take, for example, the idea of the freedom of the press. Where exactly in the Indian Constitution is the freedom of the press guaranteed? In fact, it is not guaranteed. Article 19(1)A guarantees freedom of speech and expression. Freedom of the press is a part of that by judicial interpretation. What if tomorrow the parliament was to amend the Constitution, Article 19, Clause 2, saying freedom of the press will be separately subject to certain prior restraints? I'm sure the Supreme Court will strike it down like this. Freedom of the press is a derived structure. It's a derived postulate of basic structure, but nobody will contest the validity of that when it is being read into the idea of basic structure itself. So, even though I don't accept the criticism, perhaps it couldn't possibly have applied to the idea of the primacy of the chief. So long as the historical consideration of executive branch having a non-determinative role in judicial appointments is satisfied, I think we can think of coming up with other designs and methods that might fit. But if the executive branch is given a determinative role, I don't see it being upheld. The problem, of course, this is a constitutional design problem. This is not a judicial construction or interpretation problem, but we will have to keep on throwing this unbaked cake out until the time the cake is baked, exactly as per the Supreme Court's requirements. So this perhaps is a problem that every stakeholder should learn from. This is a problem that we will not be able to solve in the Supreme Court. And I'll leave it at that. I think this problem, if at all it will be solved by wide consultation, by making sure all people come to the table, by coming up with a solution which is acceptable to everyone so that nobody goes to court. Because every time the executive branch will make sure we want to keep control of judges, of appointment of judges, the Supreme Court is not going to have it. Lastly, have judges been appointing other judges in this country? Yes, they have been. When you take the judicial service exam to become a sessions judge or a district judge, who's sitting in your interviews? It's the high court judges. Judges appointing judges is not new. Judges appointing judges is not bad. What is perhaps unacceptable to some people is, well, these judges have the power to declare law invalid. That's their job. if you have the majoritarian population elect or select judges, where the job of the judge is to make sure that these majoritarians are not able to override fundamental rights, you're going to destroy the entire objective of having an independent Supreme Court, right? And lastly, of course, Supreme Court was created by the Constitution. Its legitimacy is because the Constitution established it, not because the people are sending judges to man the institution. Thank you.
Thank you, Khagesh, for your critical observation regarding the appointment of the judges, and you have highlighted number of points. I think I'll just take a couple of points, and what Professor M.P. Singh has mentioned. There are two occasions where junior most judges superseded the senior most judges in the Supreme Court. One was in the Justice A.N. Ray. He was appointed in 1973, and another was Justice H.R. Khanna was superseded by the Justice M.N. Beg. And subsequently, Justice H.R. Khanna, he resigned, he became law minister, and he also contested for the president in 1982 election, and though he lost the election. The right time to test the independence of judiciary, according to me, so independence of judiciary, particularly in the 1975 to 1977, when a state of emergency was imposed, and we see the lot of, that is the period where when go deeper and find out how actually judiciary functioned during that particular time. And subsequently, the strength, the independence, and everything which Supreme Court of India, particularly in the field of promoting human rights, environmental law, protecting the rights of the vulnerable groups, it is started after that. In 1976 onwards we see. And not only that, also in the India become party of the series of human rights instrument. After the end of the emergency, sea changes we have seen, and we have also witnessed in the functioning of the independence of judiciary. I go one step further. The Indian judiciary is not independent today, it's a super independent. So like it's not independent, it has erogated almost every power today and functioning in that. Particularly this year is very important. There was a lot of issues, lot of concern were expressed, and even people had a fear that who will be the next Chief Justice of India. Just this month itself, people were not sure. There are a lot of speculation who will become the successor of the outgoing Chief Justice. But seniority has been followed, the seniority. And I take you further from here. Just in month of July, we had a meeting, and I don't want to name the professor was there. What he suggested in the meeting, it was a meeting of all the judges of the Supreme Court and all the High Court judges came together to find out how to reduce the pendency in India. And currently we have 3 crore cases pending in Indian courts. And large number of cases are pending in the district level, lower courts, and around 44 lakhs cases in the high courts, and around 50 to 60,000 cases. So that was the point. Almost 300 judges came, and one gentleman, one professor spoke in there. And he suggested the tenure of the Chief Justice should be 2 years. And that was objected by the person who is going to be the Chief Justice. He was also a speaker, so he took it very seriously. And what he suggested, and that I feel it's a correct interpretation also. He says, tenure of fixing tenure is not necessary. Seniority has become norm. So that has to be respected. Whether it has to be 10 days, 15 days, or 2 months, or 6 months, it has to be respected. So seniority is a norm. What is important? The policy has to be respected. What we keep on saying, judges changes, and little bit change takes place subsequently according to the moods of the new Chief Justice. So that is the concern he expressed. He expressed that concern that policy must be respected if it's a good policy which should not be experimented. And that is the important point he has highlighted. The last point and then many people sir has asked, like Professor M.P. Singh has mentioned, we don't know who has been appointed, whether the persons appointed are competent to decide, competent to sit in the Supreme Court of India. This question bothers many people for many years because we have Right to Information Act, but the procedure for the selection of the judges who has been selected by the collegium of the 5 judges in the Supreme Court was never displayed. And those who wanted to find out the information, how these persons have been, and what qualities you have looked to the 5 members of the Collegium of the Supreme Court judges. They said, no right to information, it will not cover, and they were always denied. However, changes has taken place. Now, like, they put on the website why they have been, these 5 persons have been, why the judges have been selected. So information is there. And recently, the elevation of 3 judges has taken place from the various high courts in the Supreme Court of India. But more or less, in India, people have great faith for the Indian judiciary. Despite some aberration, despite some issues, but still they feel that there is an institution which actually functions effectively, independently, impartially. That is the Indian judiciary. Despite its own some difficulties, some inherent weaknesses, but still it has managed. And with this, the last concern which we feel that under the who can be appointed as the judges of the Supreme Court of India. So there are 3 broad categories. If you look into the Constitution under Article 124, 3A, B, C, A says a person who had served in the High Court for 5 years can be appointed as either in one court or in succession. If serves in the 5 years, he can be appointed a judge of the Supreme Court. Second, a person who 10 years experience in the High Court can be appointed as the judge of the Supreme Court. But third is the last, which is unique to the India, which says, which has to be addressed by the court sooner or later, that talks about is the president can appoint a distinguished jurist. So far, no professor have been appointed as the judge of the Supreme Court, despite we have a great professor like Professor Upendra Bakshi, Professor P.K. Tripathi. There are 2-3 names, but never has been. So 3 broad categories who can be elevated. The first is a judge serving in the High Court for 5 years can be appointed as the judge of the Supreme Court. Second, 10 years, and then distinguished jurist. So court, somehow Collegium has failed, President has failed to find out like an eminent jurist. I hope that day will come when some jurist is appointed as the judge of the Supreme Court. Now, floor is open for, I don't think that another speaker will join us. Is it? So we'll finish by 3. So we have 20 minutes in hand, and floor is open for question and answers.
Thank you so much. Thank you, sir, and Kagesh for that really fascinating presentations. Both, since this title of the session says that reviewing the procedure and practice of judicial appointments, is it possible for us to a little bit brainstorm about what kind of new procedure and practice could be formulated? Because clearly the MOP that has been drafted or other things that have been said and written about is not really giving a new alternative which is even viable. And I think even though many of us will recognize that the amendment was not right and should be declared unconstitutional, which it was, most people would agree that the existing collegium system, and not just the collegium system, but the way it is actually operational, is simply arbitrary. I mean, we know for sure that there is all kinds of prejudices and biases that gets into the system, in which many really competent judges from different parts of India have been consciously not brought into the Supreme Court. And this has been now talked about it, and it's, in fact, there's a very interesting book for those who have not seen it. It's called, Abhinav Chandrachud is the author. It's called The Informal Constitution, the Unwritten Criteria in Selecting Judges for the Supreme Court of India, published by Oxford University Press. A very comprehensive book, which is a revelation as to how these judges get appointed. And because there's nothing out there, and so many new criteria have been formulated, from age to caste to religion to region to language, and then depending upon who's in the collegium, it gets played. Now, somehow, unfortunately, in all of this, gender has been totally eliminated. So you have a situation where hardly there are women judges in the High Courts and Supreme Court, and that's a separate problem altogether. So my question to both of you is that, if you were to really, think in terms of what a reform of the existing procedure and practice, what would you suggest that will fulfill the constitutional test of scrutiny, but more importantly, will be acceptable to the powers that be, which are attempting to do this. Now, of course, I take it that Kagesh's point about the fact that the intention cannot be that you want to control the judiciary and you do it. But even there's an argument that even without seeking that control, you need to reform it. And what should we be doing for that?
That has already been stated in the NJC case, as well as fourth or fifth judge's case, which you mentioned. That is, procedures have been evolved. Even earlier, the reasons had to be given for the appointment as well as for the rejection of a judge by every judge who was member of the collegium. Now it is required that not only they will be recorded, but they will also be made available to the people for knowing that what were the reasons why a person was not appointed or why a person was appointed. Though, of course, in respect of non-appointment, the judges themselves have said that negative things about a judge will not be said, which might affect adversely so far as his career is concerned. But all these things, and then there would be continuous consultation with the government. Let the government come with its own versions, and all these matters will be recorded. Means this will be an evidence. So it would be a reasoned decision. It would not be an unreasoned decision or arbitrary decision. To avoid the arbitrariness, reasons are considered to be one of the procedural fairness, and that procedural fairness actually has been ensured so far as this current procedure is concerned. Yeah.
As a matter of constitutional design, I think two things can be done. First, one of the things that weighed heavily with the Supreme Court, you already know this, was the veto power given to the two eminent people. I don't think it's a very particularly strong argument. Again, as a matter of constitutional design, as we go forward, veto can be given by any single judge in the collegium also, and per third judge's case, the recommendation can't go forward. So it's not the case that the presence of veto itself is a problem. The problem in the fourth judge's case was who the veto was given to, and it could potentially be exercised by two eminent persons who was nowhere defined. The modus of appointing or nominating these people for a single non-renewable 3-year term was effectively controlled by the political class, and that's the real thorn in the side. What if, as an experiment, the Constitution is amended and said, okay, fine, the 3 judges of the Supreme Court get to appoint 2 distinguished jurists or eminent jurists or whatever, but with a very specific definition. Now the Supreme Court knows that I get to appoint these 2 people, and let the law minister be there. The presence of law minister is single vote. That is consistent with the non-determinative role. Now if the law minister really thinks that these particular people should not be appointed, he has to convince, and the burden of proof will be entirely upon him. Otherwise the collegium, the commission will be against him, right? Those are, see, what we have to, I think one of the points that was made by Chief Justice Keher, then Justice Keher, was the Chief Justice can't be seen to negotiate with the political class behind closed doors. So if the negotiation is, if this is impossible, then let us get the judiciary the upper hand in that negotiation, so that if eventually even the judges say, fine, law minister is right, we really can't appoint this guy, then that gets converted into legitimacy as we understand it in our country. That's one way going forward. Secondly, I think about women judges, I think it's shameful that we don't have this. There's no doubt about it. But I think women have started rising in the Right, so
आप यहाँ आ जाओ, बोलना पड़ेगा.
right, so I'll just finish up here. Women have started rising in the lower ranks, and I think it's a matter of time. It will take some time until we see it, but the Supreme Court has to be very consciously aware. But I think they are now very consciously aware of the fact that there is a gender imbalance there. I think to solve this problem in a matter of 3 years is a bit unreasonable. It will take 5, 6 years maybe even.
Any question? If no, then I can request. Okay. Now I would like to request Prashant Bhushan ji, Senior Advocate, Supreme Court of India, to address all of you.
Good afternoon. First, an apology for being late. I got stuck partly in the traffic, partly at the court. I'll just give you a practicing lawyer's perspective on how I see this whole business of judicial appointments in the higher judiciary in India. As most of you are aware of, the Constitution says that judges will be appointed by the President in consultation with the Chief Justice. So for a long time, it was understood that the President, meaning the government, will appoint the judges and he will merely have to consult the Chief Justice. At that time, it was famously said that in order to be appointed a judge, you don't need to know the law, you need to know the law minister. That's what one former law minister said. Of course, it was not always the case that the government used to select their own people or politically colored people or pliable people to the judiciary. For a long time, I think this consultation was taken seriously, and by and large, judges were selected by the Chief Justice, and the government left it to the Chief Justice to select the judges. Some Chief Justices used to consult other judges. Some Chief Justices decided on their own. After, I think this business of government interference in the selection of judges began perhaps in the 80s, and then became more pronounced in the 90s. And that's when this famous statement was made that you need not know the law, you need to know the law minister. After that there was the first judge's case, then the first judge's case decided by a constitution bench, but they held that consultation means only consultation. The primacy for selecting judges remains with the government. But then came the second judge's case, and by this time I think there was a realization that government has started interfering too much in the process of appointing judges, and therefore they, in that second judge's case in 1993, was it 93? They then laid down this dictum that the process of appointing, independence of the judiciary is not merely ensured by having functional independence for the judges. There is functional independence provided in the sense that judges can't be removed except through a very complex and difficult process of impeachment. But they realized that even if the selection is left to the government and the government wants to select either their own men, meaning politically colored people or pliable people, then that would also create serious problems for the independence of the judiciary. And therefore, this principle was evolved, and a very creative interpretation was given to the word consultation. And they said that, well, in order to protect the independence of the judiciary, which is a basic structure of the Constitution, we would have to interpret consultation to mean concurrence or consent. So it meant that the government could only appoint with the consent of the Chief Justice. And not only that, they went further and said, well, the primacy of selecting judges would be with the Chief Justice. And they went even further and said Chief Justice would mean not merely the Chief Justice, but a collegium of senior judges of the Supreme Court. And that's how the power to select judges was wrested from the government and then vested with the collegium of senior judges of the Supreme Court. They said for selecting judges of the Supreme Court, you need to have a collegium of 5 senior judges, and for selecting judges to the high courts, a collegium of 3 senior judges of the Supreme Court. Of course, the names would have to come from the high court, and there would be consultation with the government. They in further refinements of this, they went on to say, in fact, today we had one of those cases listed before the Supreme Court today, because they went on to say that the government's role is restricted to only sending back the names once, meaning that the government can object to some name by giving reasons and send it back to the collegium, but thereafter if the collegium unanimously reiterates its recommendation, then those people would have to be appointed. Now, what has happened in the recent past is that in a large number of cases, today we had this case where we had filed a petition in the Supreme Court that there are a number of people, we had knowledge of only 13 such people, whose names had been reiterated unanimously by the collegium, sometimes even 1.5 years ago, but who had not been appointed. So we went to the court saying that now the court needs to issue a mandamus to the government to issue the notifications for appointment. Secondly, in an even larger number of cases, the government just sits over the recommendations made by the collegium. And we have had many instances where the government just neither sends back the recommendation nor appoints them and just sits on the recommendation for years altogether. So our second prayer was that at least in those cases where the government has not responded at all for 6 weeks, a mandamus should also be issued. So when this case came up for hearing, the Chief Justice asked us, so how many people do you think fall in this category where the collegium has unanimously reiterated? We said, according to our information, 13. He said, well, it's actually 3 times as much. But he said, hold on, for the time being, let me see if I can sort it out administratively, because this is a new Chief Justice who has come recently. 4 of the recommendations for the Supreme Court have been appointed with great alacrity within 2 days by the government. The recommendations went, and within 2 days the notifications were issued. But that's also because 2 of those names were names which were being pushed by the government itself. 2 out of those 4 names. So this is the law as it presently stands. But there are serious problems. You see, after the power of appointments was wrested virtually by the court from the government, it's true that the selections and appointments of judges have been, relatively more independent people are being appointed to the courts. I would say relatively, not necessarily. Today, for example, the 2 out of the 4 new judges who have been appointed, two are certainly not very independent. One of them recently, in a very public statement, said that I regard the Prime Minister to be my hero. And about one other gentleman, we had made a very, very serious complaint, the Enforcement Directorate of Corruption, etc. Corruption, possession of disproportionate assets, yet he has come to be appointed. So it's not that the government has now no say in appointments. What the government has been doing is, they have been pushing through their own people either by being able to influence the Chief Justice or other members of the collegium by various ways, and influence can be of various kinds. Influence can be by the lure of post-retirement jobs, and there is a new insidious way of exercising influence, which is to blackmail. If there is a Chief Justice or a senior judge who has any chink in his armor or who has done something wrong, and if the government is able to collect evidence of his wrongdoing, which they have in the last couple of cases of last two Chief Justices, in that case, this government in particular has used that information not to prosecute those judges, but to just blackmail them into submission. So, governments, and then this business of just stalling the appointments. Government just sits on the recommendations until you send names which please the government. That also is one of the tools. But there is a fundamental problem with even the business or the system of the collegium recommending and selecting judges. Because as earlier it used to be said that you don't need to know the law, you need to know the law minister. Now it is said that in order to be appointed a judge, you don't need to know the law, you need to know one of the members of the collegium. And unfortunately, this is what has been happening to a very large extent. As I said, the resting of power to the judiciary has resulted in slightly more independent judges being selected and appointed, but it has not dealt with the problem of nepotism, arbitrary selections, selections based on incomplete information and understanding. You see, how does the collegium select? What does the collegium see? The collegium consists of sitting judges who are extremely busy with their judicial work. And therefore, they do not have adequate time to devote to the business of selecting judges. Today, at least 100 judges need to be selected in the high courts and the Supreme Court every year. Now, to select 100 judges in a proper manner, you have to select from a field of at least 500. You have to shortlist about 500 people. And from that, somebody has to shortlist them. Thereafter, somebody has to see that who are the most meritorious and the most deserving of being selected. Now, this requires a great deal of time. And unfortunately, members of the collegium don't have that time. And therefore, what happens is that if some member of the collegium happens to know a certain judge of some high court, etc., whom he likes, he says that, all right, let's appoint him to the Supreme Court, and this is what is happening, unfortunately. There is no system. You see, in the first place, they ought to have laid down a criteria on the basis of which the selections would be made. If you ask a retired Chief Justice, look, how do you select judges? What do you see? Because they have no laid down criteria. They would tell you, all right, we see competence, and we see integrity. If you ask them, all right, what about judicial temperament? Do you not look at judicial temperament? Is that not an important quality in a judge? They would say, well, maybe yes, we should look at that, but they don't. If you ask them, all right, how about sensitivity to, or an understanding of the socio-economic condition of the country? Do you think that's not an important criteria for selecting a judge? Some of them would say ki no. Most of them would say no. Some of them would say ki all right, yes, maybe that could also be considered. But the point is that they have not laid down, they have not even thought about what are the attributes for making a good judge. So therefore, in many countries, in UK in particular, there is a very elaborate criteria laid down for seeing what are the attributes to be seen while making those selections. But in India, they have not laid down any such criteria. And therefore, that process of selection lends itself to a lot of arbitrariness, etc. And there is no transparency. For example, I mean, these 4 judges were selected. Suddenly, you see an announcement. Now, of course, they have started putting at least the announcements on the website. Earlier, even that was not done. You would find out who has been appointed a judge only when notification was issued and he was sworn in as a judge. Today, when the collegium makes a recommendation, within a day or two, they put out the some kind of notice on their website.
It's a resolution.
Yeah, the resolution on their website saying that we have selected so-and-so. But they don't say why they have selected so-and-so. They don't say who else was considered. And what do you do once they have selected and sent the names? You can't do anything. And here, within 2 days, the appointments were issued. I mean, the notifications were issued because 2 of the people were the people that the government had itself been pushing, 2 out of the 4, at least. So therefore, there is no transparency. We have been saying that at least the minimum transparency required is that before you make the recommendation, well before you make the recommendation, at least give the names of the people that you are proposing to recommend. At least then people will have an opportunity to send you any relevant information about these people that they have. For example, very often people know that so-and-so is a corrupt, he was the tout of such and such a judge, etc., etc. At least that kind of information could be sent to the collegium so that they could make a more informed choice. But unfortunately, in order to protect themselves from, because what is happening is all nepotism, basically. So therefore, it's only who knows whom. By and large, this is what has been happening. So therefore, they don't want to have any transparency in this process where somebody could put a spoke in the wheel by sending out some very, very critical information about these judges. So therefore, we have been saying that this whole system is deeply flawed. This needs to be replaced by a completely new system. You can call it Judicial Appointments Commission. There was a body tried to be brought in by that name, but you see, it needs to be a full-time body. You can't have an ex officio body doing this job. Selecting 100 judges of the High Courts and the Supreme Court every year is a full-time job. And you need people who are dedicated full-time with a proper secretariat to assist them, with a proper research team to assist them, which frames first the criteria, then goes about examining the people on that shortlisting and thereafter examining them carefully on that criteria and thereafter selecting judges, and with some degree of transparency, at least minimal. I mean, we may not have the US Senate confirmation hearings, but we certainly need some degree of transparency. So we have been saying that you need to have a 5-member, 7-member, whatever, a full-time Judicial Appointments Commission, which should be selected in a manner that the government does not have much say in the selection of this commission. You can have in the selection committee 1 member from the government, maybe the Prime Minister, maybe 1 other political member, let's say the leader of opposition, but you can have 3 senior judges of the Supreme Court in selecting this commission. You can have another 2 senior most chief justices of the High Court. You can have the chief election commissioner. You can have the comptroller and auditor general. So you can have a selecting body which is broad-based, which selects a 5 or 7 member judicial appointments commission consisting of retired judges, other members of civil society, etc., who can devote full time to this job. They need not necessarily be only retired judges. They could be retired judges. They could be even lawyers. They could be other people as well. I mean, in UK, for example, the bodies have been headed by non-lawyers and non-judges, the selection, judge selection bodies. So we need that kind of system because the present system is certainly deeply flawed, despite being slightly better than the. Just a word about the Judicial Appointments Commission, which was brought and struck down. The Judicial Appointments Commission bill was brought and passed and was made into a constitution amendment as well, and said that it will have 3 senior-most judges, plus the law minister, plus 1 eminent jurist. Eminent jurist plus
2 eminent jurists.
2 eminent persons, all right.
Sir, like we have to go, can you summarize in 2 minutes?
Yeah, finished. I'm finished. So therefore, that commission was struck down on the ground by the Supreme Court on the ground that it will compromise by bringing in considerable influence of the government in the selection of judges by means of getting a law minister, getting some eminent persons who could also be brought in under government influence, plus having the secretariat in the government of this body. Therefore, it would also compromise the independence of the judiciary. In my view, that was rightly struck down, but I think the time has come for the judges also to let go of this power and cede that power to a full-time independent body. Thank you very much.
Thank you. Quick 1 or 2 questions if you have specifically to the Sri Prashant Bhushan sir. If anyone ask any question to Prashant, if no. So thank you. This is time to thanks all the speakers, particularly Professor MP Singh, Prashant Bhushan ji, and Khagesh Gautam, and all the participants. I'm sure that you all might have been benefited by the discourse which has taken place in this session. Thank you very much. Now we'd like to proceed for the Supreme Court of India. Thank you.